Today, we will be covering post-trial practice. The post-trial practice is the final stage in the litigation process and occurs after a trial has concluded. After viewing this video, you should be able to identify post-trial motions, define an appeal and the appellate process, and determine the paralegal's duties in drafting an appellate brief. Rule 59 of the Federal Rules of Civil Procedure allows a dissatisfied party to file a motion asking for a new trial. A motion for a new trial must state the legal grounds on which a new trial should be granted. The court may grant such a new trial on the following grounds. The verdict was contrary to the law. The verdict was totally defective. There was irregularity in the court proceeding. There's an excessive or insufficient damage award. There was jury misconduct, or there was newly discovered evidence. Under Rule 59, a motion for a new trial or a motion to alter or amend a judgment must be filed with the court within 10 days of the entry of judgment. Some state courts allow a longer period of time. It is important for the paralegal to realize that the actual entry of a judgment could be several weeks or even months after the decision itself has been rendered. You should therefore monitor the court's docket to determine the actual date of the entry of judgment. This date begins the official post-trial time clock. As a paralegal, you will be instrumental in preparing the appeal. An appeal is filed by a party who has lost a case or who is dissatisfied with a judgment or the court order. The appeal asks that a higher court review the lower court's decision. A person bringing an appeal is referred to as the appellant. The person who opposes the appeal is the appellee. A notice of appeal is required to initiate the appellate process. After the notice of appeal is filed, within 10 days, the appellant is responsible for making a written request on a form supplied by the district court clerk to the court reporter for the desired portions of the transcript. The appellate brief is an integral part of the appeal. Research, writing, organizational, and analytical skills must be employed in this vital part of the appellate process. Because the Court of Appeals will not hear witnesses nor seek evidence, the brief must be well researched and well written to have the necessary persuasive power. After the briefs are filed with the court may schedule an oral argument for the parties to further explain their positions to the court. If the court does not schedule an oral argument, the court may proceed with rendering a written order deciding the case. There are 3 different types of appellate briefs: the appellant's brief, the appellee's brief, and the reply brief. The appellant's brief is due 40 days after the notice of appeal is filed. The appellee's brief is due 30 days after the appellant's brief is filed, and the appellant may file a reply brief, which is due 7 days after the appellee's brief is filed. The appellant's brief and the appellee's brief consist of identifying the legal issues, setting forth the important facts, outlining the legal arguments, and citing to the relevant legal authorities. After the briefs have been filed, oral arguments may be scheduled. An oral argument is allowed in all appellate cases unless the court finds that the appeal is frivolous, or the dispositive issues have been authoritatively decided, or the briefs and record adequately present the facts and legal arguments. In preparing for the oral argument, it is important to outline the argument, provide a research notebook for the justices, and arrange for delivery of the exhibits to the court. After the court hears oral argument by the parties, the appellate court will render a decision. If the decision is from the Intermediate Court of Appeals, then the parties may seek to appeal to the Court of Last Resort, or the Supreme Court. If the decision is from the Supreme Court, the prevailing party may seek to enforce the court order by engaging in any of these post-trial judgment procedures, such as a judgment creditor exam, a judgment debtor exam, post-judgment interrogatories, post-judgment depositions, writs of execution, and post-trial garnishments. To listen to a sample oral argument at the Hawaii Supreme Court, please type in this address into your web browser. The link will also be provided to you following this video. Thank you for watching today's video. Please proceed with completing this week's activities.